Morning. Good, good. So we have no movement right now. Just give me like 5 or 10 minutes to get them up here.
Good morning, Attorney Dean. You should be able to unmute now.
Yes, thank you so much.
Hello, hello. Good morning. We're just waiting for them to bring the next individual up for the first case. It looks like movement has been halted for a few moments. They said they should be up here in about 10 minutes or so. I just pulled up the. Hopefully, it's the first person that's supposed to be coming up, and I found the news article from back in 2013. I'm not sure if this is the case he's being held on right now, but this is what I got right here. So it's now fourth and long for man with history of assault cases. He was charging case number 4 on Wednesday, police said. A 20-year-old man is facing seven charges after allegedly holding a woman in Vernon Avenue home against her will in June. Geoffrey Douglas, who already has 3 pending cases in the court system. Damn, 3 cases, and is in custody. Is due back in court on September 18 and is being held in the June case on a 200,000 bond court record. Records indicate Vernon police charged him in that case on Wednesday, according to law enforcement records. The affidavit in the June case is 25 pages long, police said, and it describes an incident that the victim claims lasted over the course of several days. Douglas allegedly forced a woman to stay inside a 23 Vernon Avenue on June 17 in the presence of a small child, police said. Ooh, I need a napkin. Okay. He is accused of repeatedly blocking exits while holding either a box cutter or knife, according to an incident report. The woman claims to have eventually was able to escape out of a window, according to an incident report. Police tracked down Douglas a day later. On June 18, they built the June case over the past month and a half and charged him on Wednesday with second degree assault, second degree threatening, second degree breach of peace, risk of injury to a child, second degree strangulation, second degree false statements, second degree unlawful restraint. Douglas is also due back in court on September 18th to face third degree criminal mischief and interfering charges related to an incident August 1st incident in Vernon. Court records indicate the bond for that case is $25,000, police said. He is due in court on Friday to face a charge that he violated his probation after a guilty plea in an October 2011 assault case. Court records indicate, damn, how the hell did he end up how was he able to get out on 3 cases? Boggles my mind. Douglas on Friday will also answer a probation violation charge on a guilty plea for felony assault on a public safety official in 2012. Court records indicate those cases carry $50,000 bond each, police said. Interesting. Well, there you got it. The court system at its best. Let me I'm gonna separate these here. All right, and I'm gonna get ready while we're waiting for this. I'll be back shortly.
Michael.
Yes, sir.
Hi, my name is Dennis from Revocation. How are you?
Good. How are you?
I'm not too bad. Just start preparing my lawyer's stuff. To get everything ready.
Okay.
I'm back now. You can give me 4 days now, so.
Well, from what I understand is, I have to do an interview with a doctor, and she's going to decide whether or not I TS parallel.
Wait, whatever happened to that? I think they emailed me.
So.
Attorney Dean?
Well, I know they emailed the state, they needed my.
Hi, good morning. How
Hi,
are
just make
you?
sure you can hear me. I am hearing Douglas first, so we're just waiting for him to come up. And then
Okay,
we'll get
that's
started.
perfect.
But
No
Okay.
problem. Thank you so much.
So I have my lawyers-
And Attorney Famiglietti, we're gonna do Rodriguez after Douglas, just so you're aware.
But the thing with the sentence thing,
Morning.
so we got it started like the beginning of this month. And I'm supposed to-
Good morning, Mr. Douglas.
Yeah, good morning. How you doing? How you
Good,
doing?
thanks. We're gonna get started with your revocation hearing, okay?
Besides the, sexual abuse, I can't yet until that's done if they do decide I need it.
Good morning, I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Douglas Geoffrey, number 379-786. Today is January 15th, 2025. This hearing is being conducted via video at the BOPP Central Office in MacDougall Walker Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Geoffrey Douglas, 379-786.
Thank you. We have a parole officer present today. Please identify yourself for the record.
Michael Winnick, Office of Mental Health here.
Okay, and we have counsel here today. Please identify yourself.
Anna Dean on behalf of Mr. Douglas. Good morning.
Morning. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present all relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure, sir?
No.
Okay. You have important rights today. The right to have an attorney present, and you have counsel here. You've received the written notice of charges of violation. Did you receive the written notice? Mr. Douglas, did you get the notice?
I think so.
Yeah.
You have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights and are you ready to move forward?
Yeah.
All right, so we'll now review the charge the state your appeal is bringing against you and the information underlying each charge. So, P.O. Attorney, could you please read the charges, and you do not need to read charge number 3 as a no finding was made at the time of the preliminary.
Roger. On 9/10/24, you failed to comply with providing a urine specimen to the halfway house staff per protocol of the halfway house. Based on your behavior, you are in violation of your signed parole conditions, specifically under drug testing, as you're instructed to submit to a urine. You were made aware of the instructions to render and refuse to follow instructions.
Everything that's been told me so far.
Charge 2. On 10/10/24, you failed to attend your mandatory domestic violence group through Wheeler in Hartford, Connecticut. On 10/24/24, you again failed to attend your mandatory domestic violence group through Wheeler Clinic in Hartford, Connecticut. Charge 4. On 10/1/24, you refused to comply with a path search per halfway house policy after returning from a community pass. Charge 5. On 10/10/24, you failed to attend your mandatory domestic violence group through Wheeler Clinic in Hartford, Connecticut. And on 10/24, you again failed to attend mandatory domestic violence group through Wheeler Clinic in Hartford, Connecticut. Charge 6. On 9/17/24, you were issued a community pass to go to the hospital from 4 p.m. to 7 p.m. You called the halfway house at approximately 8:08 p.m. to report that you were discharged from the hospital. Your pass was extended until 9 p.m. You did not return back to the halfway house until 11:59 p.m. Your whereabouts in the community from 8:08 p.m. until 11:59 p.m. or entirely on 9/28/24. 12:30 a.m. You were transported to the hospital. At 4 a.m., halfway house staff called the hospital to check on your status, and hospital staff reported that you were discharged at 3 a.m. You did not return to the halfway house until 5 a.m. Your whereabouts in the community from 3 a.m. to 5 a.m. were completely unknown. On 10/1/24, you refused to comply with halfway house staff during the statewide collaborative offender risk system evaluation scores assessment. Due to non-compliant behavior, the assessment was not able to be completed. On 10/1/24, while at Open Heart,
Is that for like?
complete house count, you engaged in verbal harassment as you called staff explicit names and continued to speak to staff disrespectfully. On 10/3/24, you failed to follow halfway house rules by having food in your room. When staff confronted, you told staff to suck your dick. You continued to inform staff that their mother also sucks dick. On 10/4/24, you were given a pass in the community to seek employment. Your pass was approved from 1:10 p.m. until 5:10 p.m. You did not return back to the halfway house until 7:20 p.m. You failed to notify staff that you would be late. Your whereabouts in the community were unknown from 5:10 p.m. to 7:20 p.m. On 10/4/24, approximately 6:11 p.m., you were given a pass to the hospital. You called the halfway house at 12:45 a.m. to report that you were discharged but returned back to the halfway house at 2:10 a.m. without hospital discharge paperwork. Your whereabouts in the community from 10/4/24 at 6:11 p.m. until 2:10 a.m. on 10/5 were entirely unknown. On 10/16/24, you engaged in a verbal argument with another offender. On 10/26/24, you were unsuccessfully discharged from the Open Heart halfway house. And charge 7, on 4/17/24, you participated in a mental health intake evaluation through Community Health Resources in Manchester. The evaluation was a part of your signed parole conditions. At the time of the intake, CHR had recommended that you participate in anger management group as well as a psychiatric evaluation to determine the need for medication to address your mental health symptoms, including psychosis, mood lability, impulsivity, and anxiety. You did not comply with these treatment recommendations and were subsequently discharged. This is a violation of your mental health stipulation whereby you will participate in a mental health evaluation and treatment as deemed necessary. On 10/24/24, you failed to attend your mental health and medication evaluation through community renewal team.
Thank you. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, CT remanded custody; B, CT signed conditions of parole; C, notice of parole violation, parolee rights; D, parole violation report; E, halfway house signed agreement; F, Connecticut DOC incident reports; G, parole and community services misconduct reports; H, open heart discharge summary; I, community health resources assessment summary; J, DOC non-life threatening incident report; K, CT judicial pre-sentence investigation report; L, state of Connecticut Board of Pardons and Parole Decision Information Summary; M, Wheeler Clinic email, REDV program; N, email from Lynch from CRT; and O is CT Penal Code 53-62. Did you receive the notice of parole violation report, and those other documents I marked? Did you review them, sir?
Yeah, yes.
Okay. And council has filed the following exhibit that is pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
We do not. Thank you.
We have no witnesses.
Yeah, it is.
So
There is witnesses though, miss.
witnesses for what?
Anyway, like that was never.
Is it someone in addition to who you and I had already spoken to, who you and I had already spoken about?
I've never.
No.
So I mean.
Well, so if it's not anyone new than the people that you and I have already discussed, then I would recommend we go forward with the hearing today, okay? Because we did try and reach out to a number of witnesses you identified.
All right.
Yeah.
All right, so,
Thank you.
So I mean,
So at this time, I'm going to swear in Mr. Douglas as well as P.O. Winokur if you'd like to speak today. So I'm going to ask you to raise your right hand so I can swear you in under oath. You solemnly swear or solemnly affirm as the case may be the evidence you shall give during this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Okay. So at this time, the state has an opportunity if you'd like to speak in regards to the charge at this time.
I have nothing to say at this.
Okay. So it's not offense opportunity if you'd like to speak at this time.
Yes, thank you very much. As for the first charge, I would just note that my client does contest the narrative that's contained in the misconduct exhibit F. He indicates that on this specific date in question, it wasn't an outright refusal. He indicates that it was a communication issue. He indicates that he had given a number of different urine samples while at this halfway house. And the procedure, as he understood it for giving these sort of samples, was that the person would say, the halfway house staff member would tell him, you have us till a certain time, come down, do this. He indicates that on this specific date, he wasn't outright refusing. It was just a time issue. So I do just want to note that for that charge. As to the second charge, program participation, and as to the fifth charge, behavioral management program, my comments apply to both. I would argue for both that the standard has not been met. From the Exhibit M emails that are contained, it appears that 2 missed groups alone are not sufficient to be discharged from that program. In fact, Exhibit M indicates that clients are permitted 3 absences and are discharged on their 4th absence. Here, my client indicates that on the 10/10 date, he had been experiencing a lot of stress and anxiety due to having experienced the death of his brother and was grieving. He states that on that day he went to Wheeler Clinic and they could tell that he wasn't himself. They could tell that something was bothering him, and they told him that he could leave. He indicates that at no point was he advised that would potentially count as an unexcused absence. Had he known that, he certainly wouldn't have left. As to the 10/24 incident, he also indicates on that date that was the day that he had gone to CRT to meet with his psychiatrist about medication management. And while he was there, I think he started to experience, from what he reports, some extreme anxiety, perhaps a panic attack of some sort, and indicates that he was faint. He laid down on the floor there and requested an ambulance to be called. That's the same date that this Wheeler Clinic appointment was for. So again, I don't believe it was an intentional absence in that situation. Nevertheless, I would just argue these are 2 missed absences, which from Exhibit M appears that those aren't sufficient alone to discharge him. As to Sarge 4, I would just note he indicates for this specific incident, it wasn't an outright refusal. He indicates he had come in. It was a miscommunication issue. The staff member didn't acknowledge him when he walked in, didn't stop him from the search as he typically did. So he thought he was free to return to his room. When he went upstairs, he indicates that the staff member came up and was annoyed with him. He was a little frustrated because he felt he was just downstairs. He should have been stopped at that point. And he feels that the staff member maybe took his annoyance or frustration for refusal, but he indicates to me that this wasn't an outright refusal. Halfway house placement, just one note. I just want to say my client's reporting that on some of those dates in which they're saying he had stayed out past curfew when he had to go to the hospital, he states that on at least one of those dates, he had been waiting for medical transportation to pick him up from the hospital, but due to a lapse in insurance that he was not aware of, he waited in the lobby, he states, after being discharged for a significant period of time, wondering where the med cab was, until he was informed that the insurance had lapsed. He wasn't able to utilize that resource and would therefore have to walk back. And then finally, my comments for charge 7. For this one, I would just note that the allegation that he didn't follow up with treatment recommended by CHR. CHR records that we obtained indicate that he did actually go back for another intake on October 21st of this year, when he indicated to staff he wanted to re-engage in their services. Unfortunately, this information I don't believe was included in the PVR anywhere, and it's unclear if CHR was ever contacted to confirm whether or not he went or had re-engaged in services. So I would just note that for the record. And my comment as to the incident that led to him having that event, the anxiety situation on 10/24 at CRT, I would just echo that comment again. Thank you very much for your consideration.
Thank you. So I'll be right with you with my findings.
Hey, Miss, can I say something?
So, sir, I would advise against saying anything related to the charges. If you want to speak to your history or your background, you can do so at the appropriate time. Certainly if you want to say something, it is your right, but I would caution you as your counsel to not say anything about the charges.
Yeah, we'll see what the email says. We don't really know anything until. I know, I'm asking a lot of questions. It's been so long. I just feel like it's been so long since this started.
Hey, Miss, so basically,
I bring so many requests and nobody.
everything that I was accused of doing wasn't really that black and white, you know what I'm saying? Because they tried to say that, per policy, you're supposed to take a Medicare back, and my insurance lapsed, so I wasn't able to do that every time. So I started taking the Uber back, but it was medical reports that didn't turn into incident reports. And so I wasn't every time I wasn't
It's gonna be.
so it was times that I went to the hospital and I came right back and I had to pay out of my own pocket, and they didn't mention that. So I paid for Uber rides and I came right back because the Medicare insurance was lapsed, but I still, it's just a lot of stuff that wasn't included in what they're telling you. That's what I'm saying. So I wanted to so I was trying to bring it to your attention because there's a lot of stuff that they didn't mention, and it wasn't that black and white. You know what I'm saying? Like even the incident when they said with the staff that I said something disrespectful to him, it was an ongoing issue and it was documented.
Mr. Douglas, we explained a lot of this already to the hearing examiner, so I would just ask you to,
It's footage of that incident, and that staff had to be held back. They had to hold him back because all of this stuff, the parole was already aware of, because every incident I had, me and parole spoke about it. It wasn't like it just was lingering in the air. Me and parole addressed every incident I had, and we came up with our own plan to try to help me and move forward and do better in the future. You know what I'm saying? So, and even with Parole Officer Winnaker, I was always respectful to him. You know what I'm saying? Every time I address him with, I say, sir, and it's in text message.
Well, I'm going to give you another chance to speak in a minute, but let me just announce my findings right now, and then you'll get another chance at the end. Okay?
Thank you.
But because it's a lot of stuff.
So we get another opportunity to speak to your background and your future plans and the positive things you were doing, okay? So that would be the more appropriate time to mention some of this, okay?
But this impacts the findings she'll make too, though. You know what I'm saying?
Sir,
I don't feel like a lot of the stuff wasn't addressed right. You know what I'm saying? Like I wasn't doing the way they made it seem was not exactly what happened every time. You know what I'm saying? Like I could take responsibility for certain stuff, but a lot of the stuff I wasn't really at fault for. You know what I'm saying?
Okay, I understand. We've made our comments and argument as to the charges, so the hearing examiner is going to announce her findings based on our arguments. Okay.
All right. So
Because
I'm going to announce my findings. So on that charge 1, I do find you violated condition drug testing based on the evidence that was provided, which is exhibits B, F, and G. On charge 2, I do find you violated program participation based on evidence that was provided, B and M. As I stated, charge 3 was not taken into consideration and no finding was made at the time of the prelim. On charge 4, I do find you violated search based on evidence provided, B and G. On charge 5, I do find you violate condition behavior management program based on evidence provided, B and G. On charge 6, I do find you violated halfway house placement conditions provided on evidence that was provided, which is E, B, F, and G, parts 1 through 6, and no finding was made on part 7 at the prelim, so that's not taken into consideration. On charge 7, I do find you violated mental health evaluation based on evidence provided, B, I, and N. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to you back on history. After the state is finished, you will have the same opportunity. So, P.O. Winnaker, would you like to say anything at this time of the hearing?
Mr. Geoffrey Douglas has shown an inability and unwillingness to comply with the conditions of parole, as evidenced by his repeated noncompliance with mental health treatment, medication management, domestic violence treatment, and halfway house rules. All these behaviors are part of assigned parole conditions, which he agreed to. In the short 6 months of being in the community, he has been placed in 3 separate halfway house settings and 2 failed placements with his proposed sponsor, his mother in Manchester, Connecticut. Mr. Douglas has made it very clear to his supervising parole officer that he does not require, nor would he agree to comply with mental health treatment or medication management, despite current and past mental health assessments and recommendations. It should be noted that he required 7 trips to the emergency department at the hospital for various ailments and or his self-reports of having anxiety. His history of noncompliance has been, its pattern is dating back to 2011, whereby he was noncompliant with court-ordered treatment at the ES program and unsuccessfully discharged. Despite repeated instructions by this officer that mental health treatment and medication management are required stipulations of his parole, he repeatedly refused instructions. It would be this officer's recommendation that Mr. Douglas receive. I initially said 6 months incarceration, but I would like to increase that based on the fact that since his recent violation, he's picked up 3 additional Class A violations. On 12/10/24, Mr. Douglas received a Class A ticket for fighting. On the same day, Mr. Douglas received a second Class A ticket for interfering with safety and security. On 1/10 of this year, Mr. Douglas received another Class A ticket using housing. At the present time, Mr. Douglas is currently housed in segregation, the restricted housing unit, because of these repeated non-compliant behaviors.
I gave them that. Yeah.
So what's your recommendation?
No firearms in the house. Well, my pistol,
All right, I can hear you broke up.
cut it up and throw it away.
I would like to recommend 8 months.
Okay. Is there anything else you'd like to say before I turn over to defense?
Nothing further.
Okay, let me turn over to defense if you'd like to speak at this time.
Yes, thank you. So I would like to just address at least one of the disciplinary reports. I had spoken to my client about the one that occurred on 12/10, that first one that had to do with fighting.
Let me speak for myself, because she's not really even fully involved in the situation. Like, she's not really doing her job well enough. It's part she's not even mentioning to the stuff that's going on. Like, the incident that I'm in saying for right now, it's a medical report associated to that, and I refuse housing because I got into a fight with my cellie attacked. So I refuse housing. You know what I'm saying? So for you to say it's a medical report that's associated to that incident right now, you could investigate it, and we could continue this and then get the evidence or the proof that I'm saying, and then come back and situate this, because I'm not taking.
We're not coming back. This is the hearing right now. This is the last part of the hearing. So I want to know about your future and background and what you plan on doing when you go back out.
So
can I comment on? Can I also comment on what's going on now, like what he just mentioned?
Yes, let me get through your background.
Yes, I'll speak. Can I comment on what he just mentioned? Can I comment on what he's saying?
You can comment very briefly on it, but you already explained to us the situation from the most recent incident.
I'm talking to the other lady. I'm sorry.
No, she's correct though. I mean, I need to hear about. If you already just explained to me what happened about the refusing housing and how there was a fight and how he attacked you, so I'm listening to what you said, and I noted that.
So the first incident, there's a case report that I'm filing with a trooper, Raphael, Rafala. He's out of Hartford, Troop H, and I'm trying to figure out now. It was an incident in the other facility where I was attacked. And the CO, it was 3 parts of the incident. He's supposed to call a code. He didn't call a code. He watched the whole fight and he didn't do nothing about it. You know what I'm saying? Okay. And so they said on my part, I could file a report trying to press charges against that officer for what happened. So that's what I'm trying to do. And the third one was just, there's 3 incidents. It was one where they said, that during the incident, after the fight, I defended myself because no one else would call the code and no one else defended me. You know what I'm saying? So I was on even if she has the ticket. She also has the ticket, and it says that I was on top of my bunk, and somebody tried to attack me on my bunk. You know what I'm saying?
Okay.
And Miss Dean has the ticket. You know what I'm saying?
Okay.
So Miss Dean has the ticket, and it basically just shows that I was attacked, and I was on my bunk, and I was defending myself, and the CO was there. He didn't call the code until the last part of there was 3 parts to one fight. The third part of the fight, he called the code. So it wasn't as if it wasn't like I was attacking somebody. I was attacking my bunk, and I defended myself because he didn't help. And then they want me.
I haven't noted what you said. So let her talk about, we have to get into your future. I need to know about what you want to do when you get out and stuff like that. So
there's one more incident that I was going to mention.
Well, you only have 3 tickets.
Yes, all 3 of those you've discussed all 3 of the different tickets, sir.
Either way, it was all.
All right. Well, so then,
I'm going to speak to your background and future plans, okay? And then if there's anything I don't cover, we can address that after, okay? So, Mr. Douglas is 31 years old, born and raised in Hartford. Primary source of support in the community is his mother, Miss Brinson. He also reports 2 children, 11 and 13. While at Open Hearth in October 2024, my client unfortunately experienced a tragic loss of his brother who passed away. This has been a significant stressor for him, and he has been grieving this loss ever since. While on special parole supervision beginning on April 2nd, he has utilized the following housing. He was first sponsored by his mother at an address in Manchester from April 2nd to May 13th. From May 13th to June 21st, he went to the Bishop House New Opportunities Program in Waterbury. He reports that he did successfully complete that. He then again was sponsored by his mother June 21st to July 2nd. Then from July 2nd to July 25th, he went to Renaissance Central in Waterbury. He again utilized Bishop Halfway House until September 4th and then transitioned to Open Hearth where he was until his remand. He reports graduating from Manchester High School. He previously received disability assistance in 2021 and was most recently in the process of reapplying for those services. He reports he used to receive disability in 2021 and is hoping to get those services reactivated. On April 17th, 2024, he completed an intake at CHR in Manchester, and based on my information that I received, I believe did a follow-up intake in October of this year. He went to CRT in Hartford on September 13th to complete an intake, and then on October 24th. He also participated in Wheeler Clinic in July of this year. He did an intake and psych eval there. He did a readmission intake in October and then does report attending some sessions of Explore. As far as future plans go, he's hoping to be sponsored by someone in the community. He is open, though, to housing recommendations. He is also hoping to enroll in a trade school to further his education and was planning to reapply for disability and also is hoping to utilize a temp agency for part-time work, potentially in a warehouse. He also wants me to let the hearing examiner know that he is open to any sort of treatment recommended. I would ask that he not be held longer than the current amount of time he's been in. He's been back since October. That's nearly 3 months at this point. So I would argue that that's sufficient. This is, I believe, his first violation of his special parole. Sir, was there anything that I didn't address that you need to comment on?
What area do you want to live in? What halfway house area?
I could go live in I did good in Waterbury, you know what I'm saying? And
okay.
Probably
that's your first choice is Waterbury.
Probably Hartford, maybe Hartford too.
Hartford is like a backup, maybe.
Hartford backup.
You would you prefer Waterbury to Hartford?
I had a good communication with the parole officer in Waterbury, so probably yeah.
Okay.
But I had a good communication with Whitaker too. But I you know what I'm saying? I see part of my situation is when I get overwhelmed like that, I shut down and I stop eating, I stop showering, you know what I'm saying? I stop working out and doing all the stuff that I know that's going to help me cope mentally, you know what I'm saying? And typically I had a good communication with Whitaker, but the day he came to see me, everything, I was in shutdown mode and I didn't embrace him right. And after that, he's been gunning for me to have more time served, you know what I'm saying? But prior to that, every communication I had with him, whether it was through text or through like verbally speaking, I always was respectful and I always addressed him as sir. And I never disrespected him and he always gave me enough leverage because he know I wasn't just doing bad and just doing negative, you know what I'm saying? And until that one time he came, even when he came to see me for the visit, after I got arrested, he embraced his way of embracing me was, hey, what's up? You know, Dad, it's crazy that I leave for the weekend and I come back here in jail. You know what I'm saying?
All right, well, hold on. Well, we're talking about you coming back out. So that's what I wanted to know. So you're okay with getting treatment for mental health services when you get out?
Miss, listen, I went to CHR and I did that on my own accord.
Jeffrey, at this point.
Wait, I just want to explain to her because you didn't really explain to her. I just want to tell her that I went to CHR on my own accord and I decided that I wanted to be in. If you go through the CH record, the most recent record, because some of the stuff on that file was mixed up. Like they said, I didn't attend Willard Clinic when I left from Willard Clinic in an ambulance, which shows that I attended.
She's already made findings on the charges. She's just asking going forward if you're willing to do treatment.
Tell her, you know what I'm saying? I just want her to know, huh?
Do you want to participate in mental health services in the community when you go back out?
Absolutely. I had a domestic, because the domestic violence one the court sent me to, I had to pay for out of pocket for each individual group. I didn't have the money to do it. And I decided to switch over to CHR. It's free groups there, it's domestic violence, it's anger management. And my psychiatrist was upstairs, or my physician was upstairs. Okay. I was seeing a psychiatrist and I was seeing a therapist there too. So everything, all my conditions was being seen through one outlet. I didn't have to go to Willard. He didn't know that though. The only thing I say that I'm really guilty of was not working closely with parole. I wasn't that I didn't all out refuse parole. I just wasn't working closely with them because I didn't have to be in the halfway house. It's just my sponsor didn't work out, so I ended up back in the halfway house.
Yeah.
Sir, right, she's already made her finding on the charges. Now she's going to make her recommendation, okay?
Yeah, so just give me a second. I'm going to make a recommendation. I'm going to put on the record. I've listened to all the testimony. I have reviewed all the evidence provided by the state. I will put on the record, the offender was in the community for about 7 months before being returned to custody. He did receive 7 misconducts. This is his first parole violation. There is a recommendation of an 8-month incarceration for this violation. The offender does have, per our records, has failed 5 out of 5 community releases in the past and has received 3 DR since his incarceration. Based on all the information I have, I'm going to recommend that parole be revoked to be reparoled for April 25th of 2025. This is about a 6-month period confinement as a sanction. I recommend the following parole conditions: halfway house placement, behavior management program for domestic violence and anger management, no contact with victim AP, and mental health evaluation and treatment as deemed necessary. My findings are going to be presented to the parole board. I believe that is going to be on the 30th. So January 30th, I'm going to present this to the parole board, and the board's going to make the decision. So the board can lessen that sanction. They can keep it the same, or they can make it longer if they'd like to. But you will get it in writing about a week after January 30th, what the parole board's decision is, because this is just a recommendation. So they're going to make the choice on what's going to happen. And you can talk to your attorney as well to see what happened on that January 30th.
So basically, what is this based off? Do you know what I'm saying? What is what's the basis of me having to do? Because I know typically people only do 3 months when they get first violation.
Well, there's no typically. It depends. Each person's completely different. So it's based on each person and their behavior and the type of violation and all of that. So it is up to the board, like I said, though. So they can agree with that or they can lessen it if they like to. But you'll know January 30th what the board's decision is. Okay. So you'll know. If you have any questions, you can reach out to my office and I can let you know what the board decision is. Okay.
So can I present?
You're not presenting anything. The hearing's done, and the board just looks at the write-up from the hearing, what happened, and then they're going to make their decision.
So I won't be able to present the
no,
ticket?
You're not there.
You know how you said it? You know how you said, because with all facts included, you said that something about the tickets that I won't be able to, that the tickets was a part of why I was being.
Mr. Douglas, she adopted a 6-month recommendation. It's going to go now to the board for review. They get the final say. If the board wants to make the sanction any bigger, then you will potentially get, another hearing after that. But if they want to, make the sanction smaller, if they want to affirm the sanction, they can do one of those things. So we don't know what they're going to do yet. So we need to wait until that date comes on the 30th to determine what they're going to do. But at this point, the hearing's over. She explained her findings. She explained the basis on which she made the sanction. Okay.
Yeah, so you'll know, and then you can take it from there. So you're all set for today. I wish you the best of luck, sir.
Thank you.
Thank you.
I work for Bill's Home Appliance Installation, so that
You're all set, Mr. Douglas.
that was probably over 10 years.
You can tell the officer you're all set.
Was Home Appliance.
Hey, listen, this ain't even fair to me though, because
Pretty much.
at the end of the day, whatever y'all saying I did, I could prove that I didn't do. So how am
Sir,
I?
she already made her findings. We're past this. We already presented the evidence that we had. We already addressed the charges. At this point, the hearing is over, okay?
Gonna show up at 4 in the morning.
Damn, they
Just so you can tell the officers you're all set. I need the next inmate to come in.
pretty much next. Let's see who's coming up next, and everybody here that has tuned in. Highly appreciate you guys. Hopefully, you
That job I
guys
have with Garner
are starting off your day pretty good. I just woke up about maybe
Thank you,
about,
feel wonderful.
about an hour ago. I'm just running around right now and getting ready to start.
Thank you,
my day.
everyone. Have a great day.
And
Thank you,
also
too.
Getting ready to get the Utah stream going, which is gonna start about on about 14 minutes or so. Let me see who's the next individual that's gonna be coming up now. Should be Luis Rodriguez. I haven't looked him up yet, so I'm not sure.
Good morning.
I'll put his
No, because I,
Good morning.
my lawyer's like, you're only gonna do 6 months, you're only gonna do 6 months, you know, here's 6 months and. But, because, yeah, I figured there's no point in trying to get into industry or this and that and. You know,
going back to prison. Oh man.
anything with like school, like they said, like,
And to top it off, you're on
like, there's no point in taking
social
classes
media.
because
It's
it
all
didn't
bad.
start again until, like, from when I got in, the next round was gonna start until January.
But hey,
Which is now,
man,
which
times
is
definitely
6 months. I was just positive, everyone was
We're
telling me,
doing
oh,
things,
6 months, you're gonna
I
go
wasn't
6 months, and I get in
televised.
here, and that's.
You know whose voice that is we keep hearing through this?
That's it. That's at MacDougall. That's at
Doesn't get
the
it.
officers.
Oh,
Unfortunately,
okay.
that room is not,
It's not
Right.
padded or anything. It's not.
no.
Okay, thank you.
Yep.
He's like, man, I just want to go home. I miss my family. I won't do it again. I don't know. What do you guys think? I mean, you know, back in 2013 when he got like 4 different cases, and I'm wondering why the hell they ended up letting him out. Were they was he able to bail out of all these?
Hey, man, you know, it's crazy though, because regardless of what I say, you basing everything off of what they tell me.
Listen, I already announced my findings. I'm not
I
discussing
know,
this
but I'm
again.
just saying, just for
Mr.
somebody
Douglas?
else.
Sir, this
Mr.
is
Douglas,
the
wondering-
hearing is over, sir. Okay. The if you have it, you need to tell the officers, okay, that you're ready for them to
Yeah.
come back and get you.
Kick rocks.
You're done, right?
They're not having it today. And he's still thinking.
Do you let the officer know you're all set?
Yeah, we just gotta wait someone to come pick him up, so I'm just gonna mute on this side.
Okay.
He's ready for an outburst. Is he gonna do it? He left. He's gonna be thinking about that all day. It's gonna be running through his mind, replaying minute after minute, second after second. Let me see. Lynn put, what is he waiting for? He's waiting to. He wanted to say some things. You could see it on his eyes. You know, he kept on turning around and looking at the camera, like he had a lot to say, but they just kept on cutting him off. So they were giving him the opportunities. Next individual should be up. I'm gonna go ahead and mute my mic. I'm gonna go ahead and get the other stream ready for Utah. Should be going live in about 10 minutes or so.
Hearing examiner Meisinger.
Yeah.
The halfway house portion of this next report goes into some of what happened in charge 2.
Yeah.
So charge 2, there was a no finding. So we would waive the reading of any of what is it's a lengthy charge. So we would certainly, the defense would certainly waive the reading of anything regarding charge 2 and charge 3. I mean, I know, I guess it could be a separate basis, but just for expeditious purposes.
I mean, I don't mind that, but it is still part of the violation.
Okay. All right. I just wanted to let you know.
Just want to let the officers know who are online right now, we are running very much behind. I'm still in the 9 o'clock block with 2 inmates left, so just so you guys are aware.
Oh, okay. Thank you so much.
You're welcome.
Hearing examiner Meisinger.
Yes.
This is kind of crazy. I thought the full moon was the other night.
Yeah. Well, carried over.
Right?
Yeah.
No rest for the weary.
Hi, can you bear with us this morning? It's kind of crazy. They just shut down the hallway, so I'm trying to get them up here.
Okay,
Probably another 5 or so.
okay,
Thank you.
no problem, thank you.
Watching or if my brother comes over, like my niece, and everything. Like, what's the deal with that? Like, my brother would have to sign something, or my mother would have to sign something? Like that?
Yeah, so like, say, they need someone to situation. Like, I have a meeting to get the.
Which even before, there was never any supervised, you know, I never backed the babysit, I don't want to fucking babysit, I'm not dealing with that at all. I like to put it to the kids. Sister. Yeah.
Yeah, we pretty down. Get out.
I'm not expecting anything. I mean, even my lawyer said it, and I didn't prepare for it. She's like, it's not gonna be an easy process. I'm like, I don't expect you. I didn't expect to get through and do what you don't. That's,
Like regular probation and kind of like real team. They were doing. 15 and things like this. But they only have the other.
like I said, I'm gonna get through it the same way I do it here. So, I mean, I'm gonna do what you tell me. Yeah, I'm gonna be fine. So, I'm not a rule breaker. So that was the thing too, it's like, yeah, so I was getting worried when I was in here, so I'm talking to a bunch of people, and they're like, no, they're looking for a reason to like violate you, like, they're like, I came back on a violation of probation. But then I listened to their stories, and it's like, well, somebody that you were told you can't be around. And then the cops caught you when you were drunk, so not only were you with your wife, you had your protective order against you, you're also drunk. But then they're like, yeah, but they fucked me over, they didn't have to send me back. I'm like, well, that's like a big violation of probation, like that's. Well, that's what I figured, like, there's a dude in here, that's what he said. Cops found him drunk in a car with his wife that he wasn't supposed to be around. He's like, fucking bullshit. And I'm like, but I don't think so. I'm like, you're not supposed to be drunk on probation. You're not supposed to be drinking. Yeah, don't be drugs and all. Yeah, I don't see me having this. Like I said to Dina, you call me on a Saturday night and say key and stuff, and I'll be fine. You know, like I will be probably. You agree. Yeah. I'll tell her I can drink as much water as I want. Okay. So no. That was one of my concerns. Okay, I'm sure if I'm sure he wouldn't say no. I'm sure my uncle D, probably my uncle Dan, Daniel Kershaw. I don't know his address. I know it's registry. So I'm sure he would let me stay with him. There's a few people. No. It's just him and my aunt. And the only person that would stop over would be my cousin with his son. But again, they don't know what's going on, and they would do whatever they would necessary. But yeah, they're that, and even my grandfather would take me, and that's also my aunt Sonia. Yeah. Yeah, thank Christ. So, but your situation, there's no picture of school, bus, yeah. Yeah. There was no problem. Yeah, I'm just hoping when they do my interviews, they evaluate me. I'm hoping, like I said, I'm hoping that the fact that we see I need 2 years. I mean, I'm good with all my friends here. Like I work out every single day. It's just, I don't know. I've been pretty good about people not saying. I mean, I'm not a show mode, but you know, don't really want to be seen going to next week Friday. I can just avoid all of that and go all of it. I'll be when I get out. However long it takes. Whatever I got to do when I get out, I think I'm going to do it. But it won't be like it. No, because they said they signed me up for voices when I first got here, but they still never put me in voices. But that gets you actually out of doing, and then the evaluation they didn't start until January because they didn't get anything until beginning of January. Because the state, they said that if I waited for the state to send it in, then I probably would have BOS before the state sent it. And because, I talked to another guy in here, but he's doing 15 years for manslaughter, but he said the state took 2.5, almost 3 years to send it. My counselor said it's typical, they said it's typical in the state that you probably would deal with before they would have said that. So, yeah, so. 3 days? So you did send it and they just never, yeah, so they told me at the end of December, they go, yeah, we just never got anything from the state. They said they never got any report or anything. I fucking guess so. I don't know. My lawyer sent them a discovery and this and that. Maybe your report can get to a specific person. But there's so much shit here that falls through the cracks that, yeah, so.
Yeah.
And what happened? Please, can't get upset about it.
Good morning, Mr. Gonzalez.
I gotta do it.
Mr. Rodriguez, good morning.
Good morning.
How are you, sir?
All right. I was in dialysis.
Okay. We're about to start your hearing, sir, okay? So just be patient.
All right, yeah, we're gonna get started with your revocation hearing right now, okay? Good morning, I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Rodriguez Lewis, number 235238. Today is January 15th, 2025. This hearing is being conducted via video at the BOPP Central Office from MacDougall Walker Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Luis Rodriguez, 235238.
Thank you. And you have counsel here today. Please identify yourself.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better reader evidence will establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is Alacea, and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
We are the ones that own the restaurant. Well, I remember what I told them.
Do you have any questions? Okay. So you have important rights today, the right to have an attorney present, your counsel here, your right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
Okay, you have a right to view the evidence. You have a right to submit evidence for your case. That's here. You have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Now you're ready to move forward?
Yes, yes.
Okay, so we'll now review the charge the state appeals bring against you and the information underlying each charge. Charge 1, under release direction, GPS, the charging officer report at 9/13/24 and 9/15/24, you failed to charge your GPS for a minimum of 2 hours each day. Therefore, resulting in GPS unit shutting down on 9/13/24, 7:05 a.m. to 7:48 a.m. and 9/15/24 to 2:02 a.m. and 9:06 a.m. On 9/15/24, you failed to charge your unit for a minimum of 2 hours each day. Your device was shut down during the time of this incident from 9/15/24 at 11:27 a.m. to 9/16/24, 11:31 a.m. On 10/3/24, you failed to charge GPS for a minimum of 2 hours each day, therefore resulting in GPS shutdown. On 10/3/24, from 4:51 p.m. to 7:30 p.m. On 10/17/24, you failed to charge GPS for a minimum of 2 hours each day, therefore resulting in GPS shutdown. On 10/17/24, from 4:52 p.m. to 6:13 p.m. Charge 2 is not taken into consideration as no finding was made at the time of the preliminary hearing. Charge 3, under additional conditions, halfway house placement. The charging officer reported on 7/18/24, you visited a nurse went to Chase Center halfway house to administer medication to you. Your blood sugar was elevated and she asked if you were following your diet medication. Staff checked the last time you had taken your medication in the evenings. A nurse and discovered you had taken the medication twice since being in the facility on dates 7/12/24 and 7/16/24. The nurse stated you should be actively taking the BS levels in your Lantus every day or every night, especially due to your health conditions. She stated your blood sugar level should not be no more than 500, and that below 500 will not register on the machine. It just stayed high. On 8/29/24, refused to show Chase staff the Lyft app, but showed only a message stating 7 minutes. When resident supervisor McFadden asked you to text, you refused to speak to her. You stated that you were being denied from the facility. You then called 911. APD Rodriguez had to stop his meeting to assist with this matter. When you were given permission to leave, the Lyft driver was outside. You stated, no, I am going to call the police. Someone's going to pay for this. As a crime, you choose to let the Lyft driver leave. No finding was made at the prelim on the date 8/30/24, not taking consideration. On 8/30/24, at 5:30 p.m., you requested medical attention due to port and your chest becoming exposed. You were given a 4-hour pass to St. Mary's Hospital. You signed out of the halfway house 6:40 p.m. Were instructed to notify staff on your arrival at St. Mary's. However, you failed to make contact with halfway house. At 8:45 p.m., our staff called St. Mary's Hospital. The nurse confirmed you were not listed in their system. Subsequently, Waterbury was contacted and no records were found there either. Attempts to reach you on your cell phone were unsuccessful. You finally called Chase Center at 8:55 p.m. claiming you were at St. Mary's ER. Upon verifying both hospitals, you had not checked in at St. Mary's till 9 p.m. You were unfound for duty for 2 hours and 20 minutes. On 9/15/24 at 1:30 p.m., you went to the front office, Chase Center halfway house, requested to go to the hospital because your teeth were hurting. The nurse with hotline was called to recommend you go to the hospital. You were issued a pass to St. Mary's Hospital, left the facility at 1:47 p.m. Around 3 p.m., you returned to the halfway house with no discharge paperwork from St. Mary's. Staff noticed you had several abrasions to both elbows and knees. You stated you got dizzy and fell when you got to the horse. You stated after you got dizzy, you turned back around and turned halfway house. You were in coma for 1 hour and 13 minutes. There's no finding on that part 2 date of 9/15/24. Part 6 on 9/26/24, approximately 6:45 p.m. Your nurse arrived at Chase to administer medication to you. You asked you to please come on because she had other people to see. You told her, go, then leave. You work for me. I don't work for you. The nurse then asked you a couple more times, take your medication. You continue to tell her to leave. She then left the facility without giving you medication. A nurse from the company called the halfway house to find out what happened. Once you found out that nurse was not going to be sent, you got irate at staff, stated you were writing a grievance. On 10/13/24, during smoke break, you went up to offender Lopez, speaking in Spanish back and forth to each other in a verbal confrontation. You then walked back up to Lopez and started another verbal altercation. Afterward, you said something that to Lopez that a physical confrontation started. Connecticut State Police responded at halfway house. Both you and Lopez refused to provide a written sworn statement to the trooper. However, you informed Trooper Enzo that the reason for altercation started because Lopez is dating your accept order and were speaking about your personal business. You stated that the physical altercation started mutually due to lack of evidence provided statements and totality of the circumstances. As you started the altercation, you were issued an infraction for creating public disturbance first. On 10/16/24, on 2:13 p.m., backdoor rack was called. You told staff you're going to give the cook a cigarette at the side door. You're instructed not to go there because the side door rack was not called. You said you did not care what R.S. McLean had to say and started conversing with the cook while pointing at him. You then went into the kitchen, through the kitchen door, continued to point, did not return to the area where the wreck was originally called. On 10/25/24, approximately 7:40 a.m., it was reported that you threatened another offender. The offender reported you threatened to slap the shit out of him. When staff questioned you about the incident, you reported that Ansario had been spreading rumors about you and called you a snitch, saying that you called the cops. You stated that you were from the same block and that you will see him in the real world. Upon reviewing the camera footage, you were seen starting an argument with Nazario in the dining room while Nazario was sitting down watching TV. You walked up to Nazario and said to him, I'm dying to hit you. Nazario then stayed to hit me then. Then you told Nazario, let's go where the cameras don't see us. Let's go to the bathroom or your room. I'll hit you real quick. I'll smack the shit out of you. I'll fuck you up. Nazario then sat back down in the chair and you continued to threaten Nazario. I'll get you on the streets. Come on, let's go. Shut the fuck up and come on where there's no camera. You picked the wrong one. I'll see you on the street. ABT Rodriguez met with you, which you stated that you were upset because people were saying that client Nazario was telling clients that you had ex-client OV arrested. You said, I told him that's how niggas get smacked. I told him that's going home soon. And when I see him on the street, I was going to smack the shit out of him. CSP was notified and conducted an investigation, which included interviewing you and Nazario and reviewed the camera footage. Nazario was interviewed for the above reason why you approached him. He did not want any problems, did not want to press charges. Therefore, you're given an infraction for creating public disturbance. In the state of the following exhibits pre-marked for identification purposes as Exhibit A, Remand National Custody, B, Parole Violation Report, C, PCS signed conditions, D, Halfway House Agreement, E, GPS Agreement, F, PCS Incident Report 7/18/24, G, Offender Misconduct Report, H, PCS Incident Report, I, Offender Misconduct, J, PCS Disciplinary Report, K, Offender Misconduct Report, L, PCS Incident Report, M and N, Offender Misconduct Reports, O, at-night EM Manager, P, PCS Incident Report, Q, at-night EM Manager, R, and S, Offender Misconduct, T, at-night EM Manager, U, PCS Incident Report, B, W, Offender Misconducts, X, at-night EM Manager, Y, PCS Incident Report, Z, Complaint Ticket, double A, CSP Incident Report, double B, Offender Misconduct Report, double C, PCS Incident Report, double D, Offender Misconduct Report, double E, PCS Incident Report, double F, Complaint Ticket and Investigation Report, double G, CSI Adult Work Release Handbook, double H, Signed Acknowledgement Client Handbook, double I, Notices of Parole Violation, and JAJ is Notices of Parolee Rights. Did you receive the Notice of Parole Violation Report, and those other documents I marked, and did you review them?
Yes, we have.
All right, and council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, which is medical records, dialysis clinic, and Exhibit 3 is letter from Yale New Haven Hospital. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay, we have no witnesses, so it's now a defense opportunity if you'd like to speak at this time.
Just as to charge 1 and charge 3, as to charge 1, his light was red many times on his charging unit. It was not charging well. He had advised the parole officer about this many times. He was in the halfway house or at a dialysis when this happened many times. As to charge 3, the majority of these are with medication and confusion between whether or not the halfway house staff or the nurses were administering and verifying whether or not he took his medication. I don't think any of them are serious. Thank you for your time and consideration regarding the preponderance standard.
Thank you.
No.
All right, so what I'm going to do next is I'm going to announce my findings. So regarding charge 1, I do find you violated condition GPS based on the evidence that was provided, which is exhibits C, E, N, O, Q, S, T, W, and X. As I stated, charge 2 was not taken into consideration. Charge 3, I do find you violated condition halfway house placement based on the evidence that was provided, which is exhibit C, D through F, G, part 1, H and I on part 2, L and M on part 4, P and R on part 5, U and V on part 6, Y, Z, double A, double C on part 7, double C, double D, part 8, and double E and double F on part 9. So that includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, my client's been held since October 25th. I believe most, if not all of these violations are what I would classify as minor. He's fully disabled, 53 years of age, supported in the community by his father, brother, and most importantly, his fiancée, who's a visiting nurse. He has 5 children, 4 of which were adults. Unfortunately, in 2023, his 33-year-old son was murdered, which was a significant stressor in his life. He receives SSI disability for kidney failure. He receives dialysis 3 times a week, and he's in need of a transplant evaluation. That was scheduled for December 4th. Unfortunately, he was incarcerated. We can't say for certain whether or not he needs a new kidney, but he certainly is in transport failure, and he cannot have that evaluation while incarcerated. He was med compliant. Nurses, he was meeting with the nurses 2 times a day, meeting with his psychiatrist 2 times a week. We submitted a letter verifying the need for an evaluation for a transplant. As I stated, in one of these incidents with the halfway house, he had fallen, and that's why he didn't get to the hospital. That's why he was late. Most of these are him being either late or failing to appropriately charge. There were the 2 incidents, but neither of the victims wanted to pursue in their infractions. I'm just saying this regarding the halfway house placement. He's not a risk to himself. He's not a risk to the community. Most of these medicines were dialysis and kidney medicine, not psychological medicine that he wasn't taking. He does suffer from PTSD, bipolar disorder. The PO is recommending a lengthy period of time in jail. I know it's his 4th violation, but I certainly don't believe for the nature of these violations, especially considering his health consideration, or his health situation, that he should receive a lengthy sanction. I'd ask for that January 30th release date. Thank you for your time and consideration.
Thank you. So I'll be with you with a recommendation.
We'll do it like orange cigar bars. Not like the actual bar, but like, for the couches and cigar, I was still with all my friends. They all, even Kelly's boyfriend Johnny, he's like, bud, just gonna get through this, get the fuck out, he goes and we can have a good life.
All right, so I will put on the record, I did listen to testimony, had reviewed evidence by the state. This is the offender's 4th parole violation, or 3 prior for absconding, as well as a criminal. There are 11 misconducts.
I get all of that handled. I want to get all
that were issued. Defender was on parole for 6 months before being returned to custody. I have reviewed all the evidence regarding the offender's medical condition, and all the evidence submitted by defense, as well as taken in consideration no findings made at the hearing, as well as severity of the violation behavior. So based on this, I am going to recommend that parole be.
So that's
1
my
second.
Save money, get my bills paid up.
Parole be revoked and that you be re-paroled for June 25th, 2025. This is about a 8-month period of confinement as sanction. I recommend the following parole conditions: halfway house placement, mental health evaluation and treatment as deemed necessary, behavior management program for anger management, and general no contact with Lost 480 Lewis Ave, Meriden, Connecticut. So this will be presented to the parole board January 30th. So they're going to make the final decision on that. So it could be made lower, could be as soon as January 30th. It can also be later if the board wants to make it later. That's just my recommendation. You understand, sir?
So the hearing examiner has recommended an 8-month sanction, but that's not the final decision, sir. They'll make the final decision on January 30th. So give me a call, sir. She understands.
Out of all this time that I've been incarcerated, and this is the worst time. I really regret. This is like, to give me a chance, you would never see me again.
Mr. Rodriguez, she's already considered. She's already made her considerations. She's always made her findings. I made our arguments. Like I said, this is not a final decision. The board will decide on January 30th. Okay, have Melissa give me a call on January 30th and I'll let her know what happened, okay?
You would never see me again.
Okay, sir. The hearing is. Give me a call if you have any questions, okay, sir?
You'll know January 30th what their decision is, the parole board.
Okay. Call me if you have any questions, sir. Take care.
You're all set, sir.
Oh, no, definitely not. Nope. 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 I work on every goddamn thing. Yeah. Yeah, no, I think mentally I've been in a very good place.
Mr. Rodriguez,
Yeah,
were you able to knock on the door?
yeah.
Yes, you were? Okay.
That's been a long time, man. 8 months has been a long time, man.
Sir, I understand. Unfortunately, this is a recommendation. Make sure you knock on the door because there are other hearings after yours, sir, okay? Call me if you have any questions.
And that I was using drugs on probation. Like I was passing all my drug tests, you know.
Mira, ya.
Like recently or?
Yeah.
No, I gotta get.
Mama.
Yo, give me a second.
Morning, sir. Schaeffer. Good morning, P.O. Schaeffer. We're live streaming. I have Mr. Bugg here as well as Attorney Jones. So we're going to get started with this hearing.
Yeah.
Okay. Good morning. I am P.O. Meisker, hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Bugg Jamar, number 320903. Today is January 15th, 2025. This hearing is being conducted via video at the BOPP Central Office in MacDougall Walker Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Jamar Allen Bugg, 320903.
Thank you. And we have Parole Officer present. Please identify yourself.
Parole Officer Christina Schaeffer, Waterbury District Office.
And we have counsel here. Please identify yourself.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Bugg.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, release you and place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge. The state appeals bring against you. I will review and identify exhibit file for the record. The state will then have opportunity to present our relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
Okay. Your important rights, you have to have an attorney present, you have counsel here. You received the written notice charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses, cross-examine adverse witnesses. Do you understand these rights? Are you ready to move forward?
Yes.
All right, so now review the charge. State your appeals bring against you and the information underlying the charge. P.O. Schaeffer, please read the charge.
Charge 1, weapons. On September 29, 2024, you were found lying in the street by Waterbury police suffering from a gunshot wound. A Glock 43 9mm pistol, serial number AGED 883, was found in your was found in between the passenger side of the Toyota and sidewalk near where you collapsed. Video camera footage shows that after you were shot, you appeared to have an object in your hand before stumbling to the sidewalk, placing the object in the area where the aforementioned Glock was recovered. This is a violation of condition number 2. Obey all laws. I will not use, have my possession or control any illegal drug, narcotic, drug paraphernalia, firearms, ammunition, or any other weapon.
Thank you. And the state has filed the following exhibit pre-marked for identification purposes as Exhibit A, remand to actual custody order. B, parole condition. C, parole violation report. D, notice of parole violation. E, Waterbury Police Department case incident report ending in 2658 and the supplementary. Did you receive notice of parole violation report, and those other documents I marked? Did you review those?
Yes.
Yeah, when I get out.
Do you need to continue this hearing to contain any additional evidence?
No.
I will put on the record, I did receive an addendum, and the addendum reported on 10/21/24. A warrant was issued for the offender for the offenses of criminal possession of a firearm and possession of narcotics with intent to sell. So at this time, the state will have an opportunity to call witnesses, present evidence, and speak to any of the evidence submitted at this time. P.O. Schaeffer, I'm just going to swear you in so you could speak today. Mr. Bugg, I'm going to swear you in as well in case you would like to speak. Can you please raise your right hand? You solemnly swear or sincerely affirm, as the case may be, the evidence you shall give during this case should be the truth, the whole truth, and nothing but the truth. So help you God upon penalty of perjury?
Yes.
Yeah.
Okay. So P.O. Schaeffer, would you like to say anything at this time?
Well, it just for the fact that it was caught on video surveillance, it's very clear that Mr. Bugg did have a firearm in his possession, tried to conceal it up against the sidewalk curb there. He does have a history of firearms offenses, which I think should be noted. And like you mentioned before, this has now been taken on by the court, so he is being charged criminally with this as well.
Okay, and then I'll turn over to defense.
Yeah, thank you. May I just ask,
Yes.
may I just ask P.O. Schaeffer one question? P.O. Schaeffer, you just made reference to a video. Do you have access to that video?
I don't, it wasn't released to me at the time, you know, within the time frame of this hearing, the 7 days to submit the evidence. I did see the video, but I don't have it to submit.
May I ask you how you were able to view the video?
Yep, the Waterbury PD allowed me to view it.
Okay, thank you.
That's
Okay. All right, thank you. So in regards to charge 1 under weapons, I would just note that the facts obviously were the subject of a warrant that was submitted to court on October 2nd, which is 1 day after my client was remanded in custody, and was signed by the court on October 9th. The warrant that was submitted here as evidence is an unsigned copy of a warrant. The entire case relies on video evidence that has not been submitted in support of this violation. What was submitted was just an unsigned copy of a warrant that also relies upon the same video evidence. The defense submits that there's insufficient evidence to support a finding, and we respectfully request that Mr. Bugg's parole be reinstated based on those facts. Obviously, I think in submitting an addendum that is inclusive of the fact that my client has a pending case, there's no warrant submitted, there's no video evidence submitted, and so to find a violation here based on evidence that is not submitted, we would submit is insufficient to make a finding. Thank you.
Thank you.
Can I ask what warrant you're referring to? I don't have a warrant listed as evidence, just police report.
Okay, so, well, that's what I was referring to. I apologize. Just that the copy that was submitted had not been signed yet.
Okay. May I say something?
Go ahead.
Just so it is my testimony that I did see the video and testified to the fact that I did see Mr. Bugg having the firearm in his hand and placing it by the curb.
So just in reference to that comment, the only thing that I would just put forth is that I respect that P.O. Schaeffer representation that she was able to view the video, but however, defense counsel was not able to view that video. So we're here relying on evidence that was viewed by one side, but not made available or viewed by the defense. And my client certainly has a right to have that evidence made available to defense counsel as well as himself, so that we could have viewed it in preparation for this hearing. Thank you.
Thank you. All right, so what I'm gonna do next is I'm gonna announce my findings. So on charge 1, I do find that you violate conditional bail laws of weapons based on the evidence that was provided, exhibits B and E, as well as testimony that was provided. This includes the fact-finding portion of the hearing. Before I make recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose part of the hearing is to determine what outcome I will recommend. So I don't know, P.O. Schaeffer, you have anything else you'd like to say in regards to the second half of the hearing?
Pretty well, he was on parole. He didn't receive any misconduct or have any problematic behavior. He was referred to a couple groups in an effort to help him gain employment and be a productive member of society. Unfortunately, he didn't follow through with those programs, never obtained employment. And that's pretty much all I'd like to point out for that.
Okay, thank you. I'm not starting over to counsel.
Yes, thank you. My client's 37 years of age. He's single. He's a father of 3 children. He does have a strong support system in the community by way of his extended family who all reside in the Waterbury area. While he was in the community and released a discretionary parole on February 15th of 23, he was in the community for approximately 20 months, and I believe this is his first violation of parole. Financially, he was supported by his family, as well as he was working small side jobs. His future plans for parole reinstatement include eventually relocating to South Carolina to live with his father. He'd like to obtain his GED and eventually enroll in trade school to study electrical. He'd like to obtain a driver's license as well. He is certainly amenable to all employment opportunities once he is able to work. He did suffer a significant injury, and he's still in the process of recovering from that injury. He's eager to reunite with his children once back in the community, and is amenable to all treatment recommendations by his parole officer. I believe she did just indicate that he did not have any misconducts during that 20 months of supervision or display any problematic behaviors during his period of supervision. We would be asking that he be re-paroled at the next available date, noting that he does maintain his innocence in regards to the case that he has pending in court. He would like an opportunity, and his family would like the opportunity to attempt to post his bond so that he can establish a defense while in the community as opposed to incarcerated, as well as meet his medical needs, which he does have severe medical needs based on the incident that took place. He does indicate, and it's noted in Defense Exhibit 1, that he would like to reside furthest away from the Waterbury jurisdiction, and is interested in utilizing the Connection Incorporated Reentry Assisted Community Housing REACH program bed in any location that would be the furthest away from that area. Thank you.
So you'd like to go to like Norwich if you were a parole?
I didn't go to anywhere except for Waterbury.
That's the farthest away from Waterbury is like Norwich.
Yeah, I wouldn't mind. I said I wouldn't mind.
Okay. All right, so I have listened to all the testimony. I reviewed all the evidence. I opened the record. You were out there about 1 year and 7.5 months before being returned to custody. There is a pattern of criminal behavior regarding possession of firearms as well as selling drugs. You are on discretionary parole supervision for 2 counts of criminal possession of a gun, as well as 3 counts of possession with intent. Due to the seriousness of the charge, I'm going to recommend that parole be revoked and that you remain incarcerated until your EOS date of 5/27/2025. This ends up being 7 months and 26-day sanction. You do have 5 years probation to follow as well. My findings are going to go to the parole board on January 30th. So the board's going to review this. They have the ability, they can release you as soon as January 30th, if they like to. They can agree with my sanction, or let you out at another point if they like to. You are done in May, so it is coming up soon. Do you have any questions?
No.
Okay, so you are all set for today, sir. I wish you best of luck.
I do have one question. Like, y'all saying all this about a video, but I never got a chance to see the video. Nobody got a chance to see the video. Like,
well, I'm sure they'll be presenting that video in your criminal case.
This is enough for this type of hearing. What I have today, what I've received today is enough for a parole revocation hearing.
And so, Jamar, I can just indicate to you that I did email your counsel, and I made it very clear to him that you would like a copy of the video and you would like him to schedule an appointment with you to show you the video. So
I talked to him personally about the same thing.
Yeah, so I wouldn't say too much about that here because this matter's resolved. Certainly contact me after January 30th so I can tell you what the board's ultimate decision was, okay?
All right.
Okay, you're all set. Thank you. Thank you for your favor.
Thank you.
Okay, I had to take this week.
Good morning, Attorney Photos. I see you were able to connect. I was told you were having some issues earlier getting into the hearing. I see you, but you're still muted. I did just want to let you know we are running behind this morning, in case that wasn't already communicated to you.
Yeah, I was told now 10:45. Is that correct? Or am I up next? Or
Officer Meisinger, you're muted.
can you hear me now?
Sorry, we are behind. I'm at my 10 o'clock block right now, so I do have one case that has to go right now, and then we'll try to go to Mr. Verity.
Thank you. I appreciate it. Can you hear me? Can you hear me?
I can hear you.
All right, I'll watch the next one and I'll stay on. Thank you.
Thank you.
I think you started.
Good morning.
Good morning. Can you see her?
Yes.
All right.
Meisinger, can you hear me?
Yes.
Okay, thank you.
Perfect. PL Saunders, can you hear us?
Hi, good morning. Yes, I can. Can you hear me?
You just won't be able to see them. Alziphat. Okay.
Perfect.
Okay. I'm hoping that this doesn't go out. We've been having a little bit. Can you see me or her?
I can see all of you.
Okay. Okay. It's been going in and out, just so you know. So I'm hoping you can get through this without it hanging up.
Okay.
Okay. Thank you.
All right, so we're going to get started. Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles preliminary hearing. Certain Alziphat Alaze number 411726. Today is January 15th, 2025. This hearing is being conducted via video at the BOPP Central Office in York Correctional Institution. This is a public hearing. Public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Alaze, Alziphat 411726.
Thank you. We also have parole officer present. Can you please identify yourself?
Parole officer Saunders.
And we have counsel here. Please identify yourself.
Sure. Attorney Alfonzo, Sirica, public defender with the parole revocation unit on behalf of Ms. Alziphat.
This is a preliminary hearing, which the purpose are going to get logged. So determine if there's probable cause to believe you commit an act that violated conditions of your parole, determine the act is sufficiently serious to warrant revocation of your parole, and determine you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you placed back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearing is a reverse seal proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause in the spirit of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you of my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights today. The right to have an attorney present. You will counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
So you'll now review the charge the state your parole officer is bringing against you and the information underlying each charge. The PO Saunders, will you please read the charge?
Yes. Charge 1, obedience to the law. On 12/29/24, Wolcott police responded to your address due to reports of a dispute between you and your girlfriend, Aaliyah James. You admitted to pushing James up against the wall and eventually slapping her in the face, leading to closed fist punches being exchanged. James sustained a bruise under her eye. You also trapped James inside the room for multiple hours, utilizing threats of violence in an attempt to prevent her from leaving. You were subsequently arrested for violating Connecticut General Statutes 53A61, assault in the 3rd degree, 53A181, breach of peace 2nd degree, and 53A96, unlawful restraint 2nd degree. This is a violation of condition number 2 of bail laws.
Thank you. And the state is following exhibits pre-marked for identification purposes. Exhibit A, signed statement of understanding and agreement, conditions of parole. B, remand the custody order. C, violation, notice of parole violation. D, parole violation report. E, Wolcott Police Department incident report ending in 796. And F is pending case detail docket ending in 2445-S. I will note I received an addendum. The addendum reported on January 3rd, 2025. Charges dismissed after family violence program was completed. So did you receive notice of parole violation report, and those other documents I marked? Did you review those?
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
We do not.
Okay, we have no witnesses. At this time, the state is going to have an opportunity to make a short statement or testify with respect to probable cause and the severity of the allegations. I'm going to swear in Ms. Alziphat as well as P.O. Saunders so that they can both speak if you would like to today. So can you please raise your right hand? You solemnly swear, simultaneously affirm, as the case may be, the evidence you shall give, turn this case should be the truth, the whole truth, and nothing but the truth. So help you God upon penalty of perjury?
Yes.
All right, so P.O. Saunders, would you like to say anything at this time? This is the only time you have to speak, so if you'd like to.
No, everything I believe is written down.
Okay.
I just wanted, actually, I'm sorry, I take that back. I just
ahead.
thought it was important that the board review the actions of her behaviors for the violating of the conditions. Otherwise, I'm open to continue working with Alziphat in the community.
Thank you. So now it's Ben's opportunity, if you'd like to speak at this time.
Yes, thank you. I've provided information to the hearing examiner and to the parole officer regarding what transpired in court. As correctly indicated, my client did complete his family violence dismissal after family violence program. I'm asking that a probable cause no finding be made. All charges were dismissed. This is not a situation where my client went to court and the charges were null. These charges were dismissed. If you were to make a finding, I'm not sure how that's going to occur, but if you were to make a finding in probable cause, certainly also arguing the second part that it acts so serious that my client needs to be held pending a further revocation hearing. As of January 3rd of 2025, there are no pending charges, criminal charges, no pending technical violations. So I don't think it's so serious that my client needs to be held pending a further revocation hearing. I'm not sure what the revocation hearing would be for, since the charges were dismissed, not nolly, they were dismissed on January 3rd of 2025. So I am asking that my client be reinstated as soon as possible. Thank you.
Thank you. So before I announce my findings, I'm going to put on the record, the defendant was out there for about 4.5 months before being returned to custody on discretionary parole supervision. And it is recommendation the officer to release after disposition of charges. So regarding the charge 1, I make a finding of probable cause based on the evidence that was presented in support of the violation AEF. I do find that the behavior does meet the elements. However, I find the accident not serious enough to warrant revocation. As such, your parole will be reinstated. The records office facility, as well as your parole officer, will be notified. So you're going to be reinstated as of today. So I'm going to, it is an honor after, you are discretionary parole. So that is an honor after date as well. But I will, I'm going to, as of today, reinstate your parole.
If I may, P.O. Meisinger, not to interrupt you, I understand this discretionary parole, but anticipation of this finding, I did provide P.O. Saunders with my client's proposed sponsor, which is her mother, with an address and a phone number in the Waterbury area, if I can just make that part of the record.
Okay.
So Ms. Alziphat, she is reinstating your parole today. The issue with you is you're on discretionary parole, so it's on or after date. It might not be today because of your status on discretionary parole, but your parole is reinstated as of today.
So what does that mean though?
You'll be out sooner. You'll be out sooner than later. It might not be today. It just need to work out where you're heading. But parole is reinstated as of today.
Okay, so I'm just waiting to get picked up?
Correct.
Okay, thank you.
Okay, so you're all set for today.
Thank you, P.O. Meisinger. Thank you, P.O. Saunders.
Thank you.
Thank you.
Thank you.
Have a good day.
You too.
Good morning.
Hi, good morning.
So regarding Alicea, I have a request for a continuance. So I am going to grant that continuance to January 29th.
Who made that continuance request? I'm just curious.
The parole officer cannot
Oh,
be here
okay.
today.
I had no idea. So-
I just received notification a while ago due to the length of time we're running. So I do not need to see Alicea at this time.
Do you know when it's going to be continued to, or you'll get back to me?
That's going to be my next hearing date, January 29th.
Thank you very much.
You're welcome.
Was the defendant notified of that?
He hasn't been yet. I haven't talked to him. It just, is he there?
Yes.
Can he come in so I just let him know?
Okay, I leave you.
Thanks.
Thank you very much.
Thanks, Dave. Stay up. Now, come on. Stay up. Just a brief moment, so you probably won't be staying for long. Oh, yeah, just go and have a seat. They're gonna talk to you for a minute. Come right now. Brief moment, that's it. Make no sense.
Yeah, Mr. Alicea, we're Your hearing is just going to be continued to January 29th, for your preliminary hearing.
Okay.
Okay, just so you know,
The parole officer made the request for the continuance, sir. I did not. I just want to let you know, your hearing will be on January 29th and I will be here as well.
What's the reason for it?
I don't know. It's good
Okay,
faith.
2 weeks from today.
There was a good faith finding by the hearing examiner and by parole. And so
Okay.
any of the parties can make a request. We could have made a request if we wanted to.
Okay. Okay.
I don't know what the standard is, good faith, so it's not like for no reason at all.
Yes, yes. So Robert, you cut your beard.
No, I never had a beard.
So who was my attorney before that?
That may have been your attorney for a case in the past, but there's never been an attorney here with a beard.
Oh, wow.
Yeah,
So
I couldn't grow a beard if my
always
life
been my
depended on it.
attorney?
What's that, sir?
You always been my attorney?
For the revocation hearing, yes.
Oh, okay,
So
okay.
we're going to move on to the next hearing, and I will see you on it. If you have any questions, call me before the 29th, okay, sir?
No, actually, they moved me from building, so I'm trying to obtain a job now. And I have one more thing. They violated my 8th Amendment, proper medical care. My leg.
Okay, well, sir, we'll talk about that. That's not relevant to this proceeding, but we'll call me and we'll talk about how you can handle that with a private attorney, okay?
Okay.
okay, so Mr. Alicea's hearing number 329-019 has been continued per request of the parole officer to January 29, 2025, which is my next available hearing date. So we'll see you January 29th, sir, for your hearing.
Your name is?
Theo Meisinger.
Okay, thank you. You have a great day. All
You
right.
too. I'll see you soon.
All
Thank
right,
you.
absolutely.
I just have I have Mr. Verity and then we'll be back.
No, good job. Thanks.
Thank you.
I got back to me on Alicea. Back, bro.
And then we just have Mr. Verity.
Okay, man. Good.
Thank you.
Good morning.
Good morning.
Good morning.
Good morning, Mr. Verity.
Hi, how are you?
Good, how are you?
Good.
So I have your attorney here. So we're gonna get started with your revocation hearing, okay?
Yes.
Good morning, I am P.O. Meisinger, hearing examiner for the Board of Paroles and Paroles. This is revocation hearing concerning Verity Stephen, number 359597. Today is January 15, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Stephen Verity, 359597.
And you have counsel here today. Can you please identify yourself?
Robert Photos, 56 Boston Avenue, Bridgeport, Connecticut.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay. Your important rights today, the right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so you'll now review the charge, the state appeals bring against you, and the information underlying each charge. Charge 1, obey all laws, obedience to the law. Your charging officer reported on 11/10/24, you're involved in a theft incident at Walmart in Naugatuck, Connecticut. Upon Naugatuck police officer arrival, it was found that you worked together with an accomplice to steal approximately 38 items from the store and attempted to leave the store with them. During this investigation, you were found to be in possession of approximately $360 worth of items that were not paid for when leaving the store. You were subsequently arrested by Naugatuck Police Department and charged with larceny 6, conspiracy to commit larceny 6. In the state is filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT remanded custody. B, CT signed conditions of parole. C, notice of parole violation, parole rights. D, parole violation report. E, state of Connecticut judicial branch documents. And F is Naugatuck police report. Did you receive the notice of parole violation report, and those other documents I marked? And did you review those?
Yes.
And do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. So it's now defense's opportunity. If you'd like to speak to any of the evidence submitted at this time? I'm not sure.
Your Honor, we're not objecting. He actually pled guilty to conspiracy to commit larceny. So basically, we're in the revocation stage, and I'm going to be asking for a minimal sanction.
Okay. And I do want to put on record, we did receive an addendum from PCS. The addendum did report on 12/4/24. The offender was convicted of conspiracy, larceny 6, and did receive an unconditional discharge with the other charge dismissed. So in regards to that charge 1, I do find that you violated condition obey all laws, obedience to the law. This is based on your conviction of conspiracy, larceny 6, and received an unconditional discharge, as well as other exhibits that were provided as evidence, exhibits B, F, and D. That includes the fact-finding portion of the hearing. Before we make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to say anything at this time of the hearing?
Yes, briefly.
Okay.
Mr. Verity was released when he finished his first part of his sentence to a halfway house. He did accomplish many things. He actually got a job in the tow truck business. He got his own housing. And then the most important thing I think you should be aware of is that he did go to seek his children, visitation with his children, and to reunite with his children. He started with supervised visitation and eventually got to where now we had normal visits. He takes care of his children monetarily. The incident was just another mistake by Mr. Verity that he regrets wholly. He pled guilty to a conspiracy to commit larceny 6, which we all know is a minor offense. I'd ask for a minimal sanction.
Thank you. I just need to know, do you have a sponsor? Or do you need to go back to a halfway house?
So I have my own house.
So you can self-sponsor usually?
Yeah, that's what I was.
What town?
Naugatuck.
Is it the same address you had previously listed?
Yes, 7.
What's the street?
City Hill.
What's the number?
17.
Do you have a phone number that they were reaching you at?
203.
Yeah.
895. 8597.
I just need to know any other plans you can go back out, like job opportunities, anything like that.
So I'm continuing working with the tow company, and my mom was helping me get mental health treatment. I want to go to she has an appointment basically, like I have to call when if I come home, I have to call them and let them know I'm home. And she has it all set up where I can go there to start seeking treatment.
Okay.
I don't know if you need I don't have that information, but I can get it.
I just want to know what your intentions are, like when you get out.
To focus on building my life, focus on myself, and focus on my kids to try to build a bigger relationship with them, because I lost a lot of time with them. So I'm going to try to take care of myself mentally and worry about my kids and worry about working and continue paying the bills and stuff like I have been.
And you can still return to that residence?
Yes, I still have the house as of right now. The rent's paid up to date.
Okay. You said working with a tow company?
Yeah, like, it's listed on there, 203 Automotive.
Okay.
And there's another one up the street from my house actually that I just started working with also.
Okay.
SL Automotive.
All right, so I'm gonna be right with you with my recommendation in a second.
Okay.
I do want to put on the record, you were out there about 7.5 months before you returned custody. You are on discretionary parole supervision for similar behavior that you just received your new conviction for. It's unfortunate that you keep displaying that type of behavior that would put you on parole for. I know it is a misdemeanor, but still, you know better.
Yeah. Can I say something?
Yeah, go ahead.
I'm sorry. So that's I spoke with my mother. That was the reason she's trying to get me into this mental a doctor to talk to. Because I believe like it would really help me beneficially. Like if I start making a stipulation or something, I have to go somewhere for help. And maybe if instead of giving me such a long like I was on like reporting every 3 months, maybe don't give me a reporting every 3 months, make it more often so I'm not like so far away.
That's gonna be up to your field officer. I can't order how much.
Okay, I didn't know, I'm sorry.
No, you can discuss that with your officer back out there, you know.
Okay.
So based on all the information I have and listening today to testimony, I'm going to recommend that parole be revoked to be re-paroled for February 11th, which is about a 3-month period of confinement as a sanction. I recommend the following parole conditions, which is no contact with your co-defendants, Jamie Kelly, William Higgins, and Stephen Russell without PO's permission, as well as mental health evaluation and treatment as deemed necessary. My findings are going to go on the parole board on January 30th. So that's when the board reviews your case. If they agree with me, you'll be released February 11th. That's an on or after date. It's just your discretionary parole. So I'm trying to give you another chance to go back out there on discretionary parole. You are on discretionary parole until January of 2027 right now. So you do have a good amount of supervision left. And I hope that you work with your officer to get everything that you need out there so this doesn't happen again. Do you have any questions?
No, thank you.
Thank you very much. I appreciate it.
Thank you.
No problem. I wish you the best of luck, sir.
Thank you. Have a
Thank
good
you,
day.
Mr. Attorney Photos.
Yep. Take care.
All right, Photos. Thank you.
Good day.
Yep.
Thank you.
Violation. Good morning.
Hi, we're running behind. I'm in Cheshire quick and then I'll be over for Mr. Lewis.
So do you want me to come back in like 10, 15 minutes?
Yes, probably about that.
You got it. I'll see you in like 10 minutes.
Thank you.
You got it. 10 minutes.
I don't know how you did it, but we're only about 15 minutes behind now.
Yeah, that's because of that continuance.
Yeah, yeah,
That's the only reason.
yeah.
Good morning. Mr. Scott?
Yeah.
Okay, we're here today for your revocation hearing. And I have your attorney here, so we're gonna get started, okay?
All right.
Good
Can you
morning,
see
MP. I can see you, yep. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing, Sir Scott Arden, number 397159. Today is January 15, 2025. This hearing is being conducted via video at the BOPP Central Office and the Cheshire Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Inmate Arden Sky 397-159.
Do you have counsel here today? Please identify yourself for the record.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge to state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Your important rights today, the right to have an attorney present. You have counsel here. You've received the written notice of charges of violation. Did you receive the written notice? Did you receive the written notice stating why you're here?
Say absconding.
Right, but it's the document with the charges on it that we reviewed, sir. Did you receive that?
Yeah, they read it to me over the phone.
Yes.
Okay.
Yeah. You have a right to view evidence. You have a right to submit evidence support of your case. At this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge. State appeal is bringing against you. Any information underlying each charge. Charge 1, release checks and absconder. Your charging officer reported on 12/14/23 at 1:08 a.m. You walk out of the Chase Center halfway house, drilling parole-approved residence with 2 Walmart bags without authorization from the halfway house or parole. Staff followed you out of the halfway house and directed you to return to the facility. You refuse and continue to leave the physical premises and confined to the facility. The attempts to locate via phone calls went unanswered, not returned. No attempt to locate was conducted as all of your social supports reside in New York. You've made no attempts to contact Parole or halfway house since leaving on 12/14/23. Whereabouts of the community remained unknown. Charge 2 under travel. Your charging officer report on 10/15/24. You're apprehended by Pennsylvania Police Department on 11/15/24. You were extradited back to Connecticut by members of the Parole Fugitive Investigation Unit. You do not have permission to leave the state of Connecticut based on actions in violation of travel. Charge 3 under travel waiver of extradition. Your charging officer report on 10/29/24. Members of the Parole Fugitive Investigation Unit arrived at the Erie County Prison to extradite you back to Connecticut. You refused to comply with the extradition process, telling the officers you were not going anywhere with them. You signed conditions stating you will not leave the state of Connecticut and would abide by your signed conditions of waiver of extradition as set out in your parole application. Based on your actions, you're in violation of condition travel waiver extradition. Charge 4 additional conditions, halfway house placement. Your charging officer reported at 7/8/23. Immediately upon admission to Chase Center halfway house, you were non-compliant with prescription medication from 7/28/23 to 8/11/23. You refused to take medication for your physical mental health as prescribed. On 8/16/23 at 1:21 p.m., you left the facility on a community pass to the Western Union Office of Waterbury. You're scheduled to return to the facility by 2:45 p.m., but not return until 4:45 p.m. When asked why you're late, you stated, "Don't you come to work late sometimes?" On 8/17/23, approximately 8:05, during morning house count, you were not in your assigned room. Number 28 were not accounted for. Staff paid you the front desk. By reading that report as directed, staff searched the facility and found you in room 32's bathroom, another DOC resident. On 9/18/23 at 12:08 p.m., you walked out of the front door of the Chase Center halfway house without authorization from the halfway house or parole. Prior to leaving, you stated you had to pass the Walmart. However, staff verified that this was there was not a pass. The halfway house PD informed you that your pass was denied because you went to Walmart the previous week and had requested the pass last minute. You returned to halfway house 2:32 p.m. On 9/20/23, during a medication audit, determined compliance. Staff noticed you refused to take your medication as described. Your actions violated halfway house agreement. On 9/26/23, during a medication audit, determined compliance. Staff noticed you refused to take your medication as prescribed. On 9/27/23, during medication audit, determined compliance. Staff noticed you refused to take your medication as prescribed. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand and custody order; B, parole violation report; C, signed PCS conditions; D, halfway house agreement; E, community solutions incident reports; F, community solutions incident disciplinary reports; F, offender misconducts; H, parolee rights; I, parole violation notice; J, ticketed itinerary for 10/29/24, extradition attempt; K is refusal to sign application of parole with P.O. Donato on 2/25/19. Did you receive the notice of parole violation report, and those other items that I just stated, and did you review it?
Yes, we have.
Okay. And council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
We don't have witnesses. I will put on the record the addendum I received did state on January 26, 2024, the BOPP did issue an absconder warrant for the offender. So now it is defense's opportunity if you'd like to speak at this time.
As to the preponderance of evidence standard, only comment as to his refusing extradition. I don't think we have sufficient evidence there as to the why, the how, the when he exercised his right to refuse the extradition. And as to the halfway house placement, those allegations are almost 1.5 years old. Thank you for your time and consideration.
Thank you. So what I'm going to do next is I'm going to announce my findings after reviewing evidence submitted by the state as well as listening to testimony. On charge 1, I do find you violated condition absconder based on a warrant being issued by the BOPP and evidence that was provided in support of the charge, which is exhibits B, C, and E. On charge 2, I find you violated condition travel based on evidence that was provided B, C, and J. On charge 3, condition travel waiver of extradition, I do find you violated that condition based on evidence provided B, C, and J. And on charge 4, I find that you violated condition halfway house placement based on the evidence that was provided, which is exhibit C and D, as well as G and E on parts 1, 2, 4 through 7. No finding on part 3, which is dated 8/17/23, as there's insufficient evidence to support the charge on that date. That includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to at this time.
Thank you. My client is 35 years of age. She receives support from his mother, father, and 3 sisters. The majority of his his contacts and support are outside the state of Connecticut. While in Connecticut, he worked in the shelter. He formed a resume. He got his identifications. He was working at the shelter in a custodial and maintenance capacity. I'm not sure where he wishes to be placed in a halfway house in Connecticut, sir. You did not specify with my social worker. When released, where in Connecticut would you like to be housed?
I want to go back to the same halfway house I was at. That's the only halfway house I stood there for 6 months.
Where is that?
Oh, Chase.
What town?
In Waterbury.
Waterbury. Okay, thank you. He wishes to return to obtain his GED. He wishes to obtain a security license, and he was working towards it when he was in the Bronx. He wishes to be released as soon as possible. We're basically looking at an absconder. Many of those violations are minor, having to do with not taking medicine some year and a half ago. I think the recommendation of parole officer is excessive, 18 months to 2 years. We'll essentially be warehousing him. My client does suffer from bipolar disorder. He can be impulsive at times, and I think when he's medicated, he makes better decisions. Thank you for your time and consideration.
I also have my certificate. I also have my certificate I took classes for Narcan. I also want to put that on record. I have my Narcan certificate license. I achieved that. Also, like you said, I achieved my resume. I fared well with my identification card. I was helping, voluntarily working. I was in the shelter. There's a lot I was going on, and the only problem was just that the location for me not receiving my ID and me being in this residence where I'm not from. So it was just a little difficult for me. But besides that, I was being successful in society. I was showing you guys that I can work in society on my own without having to be always monitored or supervised. You know, I actually accomplished in society on my own. And regardless of what you're going to give me today, I want to say that I'm proud of myself for accomplishing these things that I did on myself in society. That's what I had to say.
Sir, are you willing? You're going to be on parole, I think, until 2032, correct?
No, that's incorrect.
When do you have to, what's that?
2029. That's 10 years.
29?
From 2019.
I was asking the hearing examiner, actually. When is his parole over? Because our information is 2032.
May 10th, 2032.
Okay. It may have been extended because of your absconding, sir.
Every time absconds.
Majority of the time I was incarcerated. That's what I'm saying.
Sir, we're not going to get into an argument here as to when your release date is. We can talk about that another time. Okay, but basically the gist of my questioning was, because you're going to be supervised for some time, you were talking about how well you did when you were independent. Are you willing to work in Connecticut with a parole officer?
I never received one to start with.
But if you were to get one,
I gotta get out first.
I'm just trying to help here, sir, by asking, because you absconded, whether you're willing to work in Connecticut with a parole officer to better yourself.
Do I have an option? That was you
telling me? No, you don't have an option, frankly. But
all right, then. So that's not even a question to even.
Okay, sir, I was just trying.
Well, you do have an option. If you're telling me you're not gonna and you want to stay in there, I can keep you in there. So, I mean,
I don't want to stay here. That is.
I know, sir. I was trying to help you.
That's not one of my options. Staying in jail for what?
Okay, I was trying to help you, sir, to see if you were willing and able to work with someone. Thank you.
Yes.
Good.
Yeah.
All right, so I'll be right with you with a recommendation. All right, so I do want to put on the record, Benner was in the community for about 4.5 months before absconding from supervision to a later state. There are 4 prior parole violations for absconding. This is the offender's 5th violation. as well as the offender was found guilty of refusing extradition. There are 5 misconducts that received prior to absconding. 18-month to 2 years is recommended by the field officers. Based on all the information I have, I'm going to recommend that parole be revoked to be reparoled for September 15th of 2026, which is an 18-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, a general no contact with Walmart loss prevention, no contact with co-defendants, Tyreek Dennis, Terrence Smith, behavior management program for anger management, and a mental health evaluation and treatment would be necessary. My findings are going to the parole board on January 30th. So the board's going to make the final decision on when and if you should be reparoled. This is just a recommended. Hey, do you understand?
No, I don't understand.
Sir, it
says 12 months. The max is 12 months.
Sir,
no,
that is an old policy.
So you might as well max me out. Max me out.
Sir,
max me out. Max me out.
Sir,
I wouldn't do that. Nah,
sir,
I want to get maxed out. Max me out.
That is not a policy. There is no policy, sir.
Max me out. I'm leaving the state if you let me out. Put it like that. Max me out. Put me like that. Max me out. I don't want to deal with your state. Max me out. Max me out.
There's no longer.
Max me out, man.
Are you gonna talk over me or?
Man, max me out, man. So when I walk out the state, I ain't looking back. Max me out. Max me out.
It's up to the parole board.
It's up to you. You recommended it. It's up to you. You fucking recommended it.
It's a recommendation. I'm not the parole board.
I don't care. You can't recommend it. You can't recommend it. Something it's only 12 months. You talking about?
That's not true. It's not only 12 months.
Yes, it is. Look, check it out. So max me out. So why you can't max me out?
No, the board can't.
Max me out. Man, sometimes day. Max me out. Out of here.
All right. So that concludes the hearing.
Yeah. What you talking about, bitch?
Have a good day.
Suck my dick.
Thank you.
Good morning, P.O. Goodman.
Good morning, sir. How are you?
Oh, just call me Rob. Don't call me sir.
Good morning, Rob. How are you? Call me Kim, please.
Okay, Kim. Good morning.
Good morning. Good afternoon.
Well, that was a fiery end.
Yes, we are going up in flames today.
No.
Let's just hope they're there.
Let's hope.
I did call Garner to let them know an updated time, so a CO should be nearby.
Thank you.
They're usually pretty good. I guess I should say Happy New Year. I haven't seen you guys since the New Year.
And Happy New Year's.
Hope everybody's holidays were good.
Hope yours was too.
Quiet. I took a staycation.
That's the best thing.
It was nice not to have an alarm clock going off at 6:15 every morning.
Let me try to hold it back.
Just take a look up. This is my testimony.
Perfect, we'll be down shortly.
Thank you.
Did he say he'll be right with us? Is that what he's?
He said he'll be down shortly.
Oh, okay.
So they probably have to pull him out of his unit.
Okay.
I don't know what block he's on, so I don't know how close he is to the visiting area.
It's just par for today.
As long as he's coming down, it's all good.
Yeah. We couldn't have something go smoothly today, could we?
Yeah.
I will try not to contribute to your both of your bad days.
No, I think we're good. I think it's all good.
We're in the straightaway now.
Oh, well, that's good.
Yeah.
I just had a quick question. You have an interesting one coming up, I believe, after Mr. Lewis.
No, actually, that's continued.
Oh, okay, good. Then I was
This
going to
is-
say if you would mind if I'd stayed on and watched it because we're so familiar with that case.
Right. Yeah, no, that's been continued. Actually, I need to put that. I do want to put that on the record, which I will do now, just because we're waiting.
Sure.
In regards to the 11:45 hearing for Charles Cornelius, number 296776. This case has been continued to be heard for January 29th, 2025 for the preliminary hearing.
That's it, no doubt. No doubt. That's it. You can go right up in here, they should all be waiting for you, okay?
Thank you. Good morning, Mr.
How
Lewis.
you doing?
Good, how are you?
Hey,
Good morning, Marlon.
morning.
Hello,
We're
Mr.
here.
Lewis.
We're here for your hearing today, so we're gonna get started, okay?
All right.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Lewis Marlon, number 379405. Today is January 15, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Marlon Lewis, 379405.
And you have parole officer here today. Please identify yourself for the record.
Parole Officer Kimberly Goodman.
And we have counsel here today. Please identify yourself.
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure at this time?
No, Your Honor. No, Your Honor.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah.
Okay, you have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
Okay, so now review the charge. The state your appeal is bringing against you and the information allowing you charge. So P.O. Goodman, if you could read the charges, you don't have to read number 1 as a no finding was made at the time of the prelim.
Yes, thank you. One moment, please. Obey all laws. Obedience to the law. On 10/23/24, you made threats to assault Whiting forensic staff, hospital staff on Unit 6. You entered another patient's room unprovoked and physically assaulted them. While the patient was lying in his bed, you jumped on top of him and punched him in multiple times in the face. You were face and head. You were restrained as you presented an imminent risk. You continued to make threats of assault on staff and you spit on the doctor. You had to be moved to another unit. Your behavior meets the threshold for Connecticut General Statute 53A-60 assault second. On 10/24/24, you became agitated and attempted to assault staff on Unit 4. You threatened to stab staff with a spoon. You had to be restrained. You were combative. You bit the inside of your mouth and spit blood at staff. Your behavior meets the threshold of Connecticut General Statute 53A-181, breach of peace in the second. Based on your behavior, you are in violation of special parole condition number 2, obey all laws. Mental health treatment. On 10/24/24, you were remanded from Whiting Forensic Hospital per the request of Whiting staff for threatening and assaultive behavior. Because of your removal for such behavior, you were unsuccessfully discharged from your mental health treatment program. You are in violation of your conditions of parole, additional condition, mental health treatment.
Thank you. And the state is following exhibits that are pre-marked for identification purposes as Exhibit A, signed parole conditions, B, remand national custody order, C, notice of parole violation, parole rights, D, parole violation report, E, Whiting Forensic Hospital integrated progress notes, F, misconduct report, G, DOC disciplinary report, H, email from Dr. Berger, I, documented conversation between PS Man and Dr. Berger, J, DMIS police case incident report, K, email from Lieutenant Driscoll, RE assault, L, assault second description, M, breach of peace second description, N, revocation hearing summaries, O, misconduct report, and P is probate involuntary commitment decree. Did you receive notice of parole violation report, and those other documents I marked? Did you review them, sir?
Yes, we have.
Okay, and council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
You don't have any witnesses. At this time, I'm going to swear in P.O. Goodman as well as Mr. Lewis in case you want to speak.
I'd ask that you not swear in my client because there is a pending assault charge in Middletown Court. And I'd ask that I'm going to advise him today not to make any statements on the record about what may or may not have occurred there. So, sir, I don't want you to make any statements about what did or occur or didn't occur at Whiting because I don't want them to use any of those statements against you, okay?
All right. So, P.O. Goodman, please raise your right hand. You solemnly swear, solemnly, sincerely affirm, as the case may be, the evidence shall give, sir, in this case, shall be the truth, the whole truth, nothing but the truth, so help you God, if I penalty of perjury?
I do.
Okay, would you like to say anything right now in regards to the charges?
Just related to, with regards to the charges, Mr. Lewis was placed at Whiting Forensic Institute on a involuntary probate commitment as he was found to be gravely disabled and a danger to himself and other people. And as evidenced by his behavior on said dates, that was actually probably the best decision that the court could have made at the time. This is also the fourth time that Mr. Lewis has been involuntarily committed to either Whiting Forensic Hospital or Connecticut Valley Hospital because he has been a danger to himself or others. And it is accurate that what Attorney Famiglietti said, that we have learned that there's a pending matter warrant out of Middletown Court that has yet to be adjudicated. Mr. Lewis has a significant history when being out in the community and in the institution, and it should be of note that the violence that he displays is for secondary gain and has been documented multiple times that when he has committed those assaults, he has not been found to be paranoid, delusional, hallucinating, or disorganized.
Thank you.
Thank you.
Okay, turn over to counsel if you'd like to say in regards to the charge.
Yes, as to the charges, obviously a no finding was made as to charge 1. I think a no finding should also be made as to charge 3, because the only reason he was discharged from treatment was because of the remand. It wasn't him not cooperating with treatment. And so I don't believe there was any intent, no action of his own ended that treatment. It was because there was an order remanding him. I have no comment as to charge 2, other than I don't think anyone can jump inside anybody's head, whether you be a psychiatrist, a psychopharmacologist, any type of doctor, trying to estimate or try to understand what motivates someone who has a compromised brain chemistry. There's no such thing as a perfect brain. We all suffer from different chemistry in our brains that causes us to act or not act in certain ways, shape, or form, and trying to assume or judge that someone's mind wasn't compromised when they were acting, when they do carry a diagnosis and they have been involuntarily committed because of their grave disability. I think it's a little presumptuous to assume when someone is acting under color of brain chemistry that's disturbed or not. Thank you.
Excuse me, guys. I'm just wondering if it's going to be past 12, because if so, I'm going to have to put them on my count.
cut close to it.
Okay, thank you.
If, okay, thank you. So what I'm gonna do next, is I'm gonna announce my findings, based on evidence and testimony that I have reviewed. So in regards, like we had previously stated, charge 1 is not taken into consideration, no findings made at the time of the prelim. On charge 2, I do find you violate condition obedience to the law based on evidence that was provided in support of the charge, which is exhibits A, E, J, K, L, part 1 and A, E, M, part 2. Regarding charge 3, I do find you violated condition, additional condition, mental health treatment based on evidence that was provided, exhibits E, H, I, and P. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Goodman, would you like to say anything at this time?
Yeah, this is the 5th time that Marlon has violated since his release to the community. He's had one escape, which was a Class E felony that he was convicted of while he was at a halfway house. He had one absconding, he had one technical, this would be the 2nd technical, and he had another criminal charge for very similar behavior at Connecticut Valley Hospital. We have attempted to work with Mr. Lewis since 2019, and he continues to be uncooperative with his, he continues to be uncooperative with abiding by his parole conditions of parole. Again, as I stated earlier, a court on 4 separate occasions has found him to be a danger to others, and he has presented that way in the community and in least restricted, controlled environment, and he continues to utilize violence for secondary gain. I don't know how many times a court needs to deem him gravely disabled and a danger to himself or others before we stop kind of putting him back in the community and creating other victims. We have created at this point now, if I'm not mistaken, 1, 2, 3, and potentially with a pending case, 4 victims of Mr. Lewis's violence. And we are recommending a full revocation to be reviewed as policy. I believe it's annually unless that's changed. He would be found gravely disabled and a danger to others again if we released, and at that point would have to be placed back at either Whiting or CVH. I'm not sure how many times we need to do that or how many times he needs to prove to the parole board that he's not a good candidate for parole, even though special parole was ordered at the time of his sentencing. I do want to put on the record that at the time of his preliminary hearing, and it is in the prelim summary documented on multiple occasions, that he claimed that the reason for his behavior is that he was allergic to Depakote. Nowhere in his medical record, and I've checked the EHR with the Department of Corrections and with DEMIS, is there an allergy to Depakote. In fact, his only allergy listed, which is a mild one, is to risperidone. So I want to make sure that that's on the record, that, you know, you can either you're mentally ill or you're not. Not all people who are mentally ill and diagnosed with a mental illness and or are meet a hospital level of care assault people on a regular basis for secondary gain. And it was documented in the reports that Mr. Lewis did not want to go to a step-down unit from Whiting at Dutcher and want to be released to the community, and thought that if he committed these acts that, you know, he would get his way. And I'm sorry to say that it didn't work. And it didn't work the 4 other times that he's been violated as well.
So if he gets, when he comes back out, would he be going back to Whiting or CVH?
Potentially, yes, if he's found to be gravely disabled and a danger to himself or other people. I would say at this point, the answer to that question would be yes. However, I'm not sure how willing or unwilling Whiting and CVH are going to be able to work, because in the past 6 years, he's created several victims, including staff over there. It's not just other people who are struggling and who are mentally ill. He takes advantage of, he assaults the staff, but he takes advantage of people who are weaker than he is. So, you know, he does not have any place to go.
That's not
That's
true,
been
but-
presented to us. I mean, I did get the defense's evidence yesterday, and it just says that he's amenable to everything. So I really don't know what that means, because in 6 years, he hasn't been amenable to much.
Okay.
Maybe heard now?
And the other, you
Now
know,
that I have 1
the other
minute,
thing I
now
want
that
to
I
say
have 1
too.
minute.
Yep, the other thing I want to say too is we don't know what's going to happen with the outcome of this new criminal charge.
That's irrelevant to today's proceeding.
But you put it on the record, so we still
But
don't
it's
know
still-
what's
no, no,
going to
it's
happen with
irrelevant
it.
as to the decision today.
Okay.
Can I be heard now in this last minute that we have?
You can, yeah, well, it's now going to be your defense's turn, so if you'd like
Thank
to
you.
speak. Yep.
No, take all the time you want. They can wait for the count. That's
Yeah,
fine.
you're not we're not sending him back until we're done, so you have
Thank
time. Yeah.
Okay, so my client doesn't have a choice here today. He's either going to go to Whiting Forensic because he's been committed there by the probate court. And I spoke with probate court in North Fairfield. So he's the subject of an involuntary commitment until that's changed. So he's either going to be at Whiting Forensic or he's going to be incarcerated. And there's no question he's gravely disabled. So our question today is how much time he's going to serve in jail. Are we going to warehouse him in jail? Or are we going to send him back to the treatment, which he just so desperately needs? What happened on that day is going to be decided in court as to whether or not he's going to be punished. And there's no information that he's not going to be able to go back to Whiting Forensic. He's under an order. That's speculation. So our decision today is what the sanction should be for this conduct. That's our decision today. And I don't think revoking his parole is the answer. My client is 34 years of age. He's involuntarily committed due to his mental illness. He's going to be a danger to self or others, and they knew he was a danger to self or others when they committed him to Whiting. He's going to be a danger to self or others if he's in Whiting, and he's going to be a danger to self or others if he's incarcerated. It's as a result of his mental illness. It's as a result of his compromised brain chemistry. This is like diabetes. This is like a heart condition. My client was born. He's been on SSI disability since he was 16 years of age. He needs management. He needs appropriate treatment. I think it's noteworthy in the Department of Mental Health and Addiction Services Public Safety Division report that both the clients are at end of sentence and have a legal status of probate commitment psychiatric. That's both parties to this argument. The patient did not wish to pursue charges due to not wanting to be labeled a snitch. This is the end of the report from the police that were in charge of managing the situation. The Demas Police Department will not be pursuing criminal charges in this matter. This incident will be handled clinically. It's only afterwards that the warrant was submitted. This type of conduct, unfortunately or fortunately, occurs while someone with a mental illness is in a setting such as Whiting Forensic. The answer is not to take someone with a mental illness and revoke their parole because they are symptomatic. Any conclusion that he was not acting through the filter of his mental illness is preposterous. His personality, his actions, his sense of self-being, his decision-making process is all filtered through his compromised brain chemistry. There's no separating when he's acting one way and when he's acting another way. They're all actions. His intent or lack of intent or acting or inacting is all tied to his decision-making process, which we've known is gravely disabled and compromised. I think if we throw away the key today and send him in jail, that is the wrong answer.
May I just may I just clarify on the record that the charges that are currently pending have nothing to do with what was charged on this PVR. It's a completely separate incident and not related to any of the charges. That it's a whole nother charge, and it's not charged in this current violation.
Which further proves myself that this is conduct related to his mental illness. You cannot separate his actions and say this is intentional and say, no, this isn't intentional. This is all colored by his mental illness. And persons with mental illness, as decided by the probate court in this set of circumstances, has placed him at Whiting Forensic. We don't just throw away the key and totally revoke someone's parole because they're difficult or because they're assaultive.
Well, this behavior only happens in the context of when he's released from custody. It doesn't happen if you review his DOC history. It doesn't happen. It doesn't occur within the Department of Corrections. It occurs upon release.
In the past, there's no reason to take away his freedom any further than it's already been taken away. Thank you.
My understanding is also the facility will have to reapply for another commitment.
Fine.
Because
let
that
them reapply.
Commitment became vacated, so there's no guarantee he can go to Whiting.
People having to do more work, people having to do their job. I'm just saying, should not be an impediment to my client getting the treatment that he needs. Thank you.
All right. So I've noted what both the state as well as defense has stated. So I'll be right with you with my recommendation.
Thank you.
I will put on the record that the offender was on parole for about 2.5 months before he was returned to custody for this violation. He does have 3 prior violations, a criminal misdemeanor and technical, as was previously stated on the record. So this is his 4th parole violation. He does have a history of violence and absconding, as well as which includes assaultive behavior. And I just want to put on the record too, as well, that I am noting that there are currently pending charges that are not related to this parole violation. So based on this information that I have and on testimony provided today, as well as the interest of the offender, I am going to recommend that parole be revoked and that the offender be re-paroled for January 2nd of 2026, which is an approximate 1 year and 2-month period of confinement as a sanction, leaving the offender with 1 year on special parole supervision. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with victim GHOBMB, behavior management program for anger management, general no contact with 263 Lower Street, New Britain, Connecticut, and mental health treatment and medication compliance. My findings are to go to the parole board January 30th. So the board's going to review this and they're going to make the final decision on what happens. The board can agree with my sanction, they can lessen that sanction, or they can revoke all the special parole as well. So it will be up to the parole board. Mr. Lewis, you'll know on January 30th what the parole board's decision is, and if they're going to re-parole you, and if they're going to agree with my date or list a different date. Do you understand that?
So what's going on when I go to probate court?
So I'll explain it to you. Nothing's going on at probate court right now. I spoke to probate court. You're not represented in probate court. You don't have a conservator. That lapsed. What happened today is that the hearing examiner recommended a 14-month sanction. So that is a release date of next January, the beginning of next year. So just over a year, but the time you've done has already counted. Okay. That's not a final decision. That final decision will be made by the board, sir, on January 30th. So at the end of this month, you'll find out what your release date is, and you can call me and tell me, and I'll call you and tell you as well. You'll get a letter you'll also get a letter in the mail, sir, from the board telling you when your release date is, okay?
All right.
All right?
Thank you. Thank
You're
you.
welcome. Good
All
luck,
right, you're all
sir.
set for today.
Thank
Bye,
you.
Marlon.
Thank you.
You said January what?
January 30th is the decision. And
Okay.
the release, okay, sir?
All right.
Okay, thank you, guys.
Thank you, guys.
Thank
Have a
you,
good day.
Kim.
Bye, Rob.
Bye.